Okay. Good morning.
Good morning.
Thank you for coming today. I am Sherry Boston, and it is my honor and privilege to serve as the District Attorney for the Stone Mountain Judicial Circuit here in DeKalb County. Today, I am joined by Cobb County District Attorney Flynn Brody, Talawega Judicial Circuit District Attorney Jonathan Adams, and Augusta Judicial Circuit District Attorney Jared Williams. Under Georgia law, when district attorneys take office, we must hold up our right hand and swear to faithfully and impartially and without fear, favor, or affection discharge our duties. It is an oath that we take seriously and the one that guides the work we do every day as we safeguard the communities that we serve. But recent actions by some in the Georgia General Assembly show that instead of making decisions without fear, they would prefer that fear guide prosecutors' every move. In May, Governor Kemp signed Senate Bill 92. This new law creates a commission with the power to second-guess prosecutors, or our policies, our decisions, investigate us, and remove us from office altogether. Under the law, a prosecutor the commission cannot serve again for 10 years. One of the most important responsibilities we have as district attorneys is to determine which cases to pursue, also known as prosecutorial discretion. My top priority is to keep my community safe, but there is no one-size-fits-all formula to accomplish that. Every prosecutor must decide which crimes to prioritize and where to adopt more holistic approaches to improve community safety, like substance abuse treatment and job training. Under this law, something as simple as offering a teenager an opportunity to enter a pretrial diversion program or deciding not to go forward with charges in a drug possession case could bar us from this work for a decade. But this law is not just an assault on prosecutors. It is an assault on our democracy, a direct threat to every Georgian who exercises their right to vote, their right to choose the person who they think best represents their values in the courtroom. And it says to them, if the state doesn't like your choice, the state will choose for you. In 2020, record numbers of Georgians made their voices heard at the ballot box, with nearly 5 million votes cast statewide. But under this law, a commission of just 8 could silence an entire community of voices and override the will of the people. We will not let the people of Georgia be silenced. We will not let state lawmakers dilute democracy. That is why today, we, a bipartisan coalition of prosecutors, have filed a lawsuit against the state of Georgia to challenge Senate Bill 92. We believe the law is unconstitutional, and we believe it should be declared void. All of us are sworn an oath to serve faithfully and impartially without fear. And while we recognize this legal challenge will likely put a target on our backs, we will not fear. We will not falter in our oath to the people of Georgia. Next, I'd like to introduce District Attorney Jared Williams of the Augusta Judicial Circuit.
Thank you, Sherry. Good morning. My name is Jared Williams. I have the honor of serving as District Attorney in the Augusta Judicial Circuit, which comprises Burke and Richmond counties. In 2020, I was part of a decisive and unequivocal cry from communities across this state to improve the criminal justice system, to make it more fair, more just, and more effective at reducing crime and promoting safety. History was made in the way of progress, and as a result, legislation was introduced and signed to roll that progress back. The citizens of my community deserve better. This legislation seeks to shut prosecutors up, but I didn't march the streets in the Augusta heat to bite my tongue now that I'm here. This legislation strips prosecutors of our discretion, but I vowed to use this office for good and end the decades of harm done to the powerless. This legislation violates the voter's choice. The people didn't choose us to be robots with law degrees. They chose us to make the tough decisions that ultimately protect our communities. Standing with me is a group of prosecutors. We don't back down from bad criminals who hurt people, and we won't back down from bad law and harmful policy. I'm willing to lose my job to do the right thing. But what does it say about us that anyone should have to make that choice? I now introduce DA Jonathan Adams.
Thank you, Jared. Good morning. My name is Jonathan Adams. I am the District Attorney of the Talladega Judicial Circuit, representing Butts County, Lamar County, and Monroe County, Central Georgia. We're a small rural area. My rural community elected me to represent them and their conservative values. And although I may disagree with DA's decisions in other communities, I believe it is their right to make those decisions and represent their community and their constituents. As a member of the judicial branch, I believe we have a right and a need to make hard decisions regarding what is appropriate to prosecute. We may not prosecute adultery, fornication, or sodomy, but they are all still crimes. We may not be able to get misdemeanor amounts of marijuana tested at the GBI crime labs, but they are still crimes to possess. These are simple examples, but we also face tougher and more complex issues. And so I stand with these district attorneys as we move forward against this legislation in hopes of judicial and prosecutorial independence. Thank you.
I will now invite up Josh Rosenthal, our lead attorney, to give his remarks. And I'd invite all of our attorneys to come over.
Good morning. My name is Josh Rosenthal. I'm Legal Director of Public Rights Project. At Public Rights Project, we partner with state, local, and tribal governments across the country to help them fight for civil rights and economic justice. But in recent years, we've seen a disturbing emerging trend of state governments that don't like local choices about how to make their communities safe, healthy, and equitable. And so these state governments are taking power away from local communities and the officials that they've elected. SB 92 here in Georgia is one of the latest examples of this disturbing trend of preemption and state abuse of power. And so we are proud to partner with these 4 district attorneys, as well as our co-counsel at Washington Dreyer & Associates and Bruce P. Brown Law, to fight back against this overreach. Today, we are suing the state of Georgia and the members that have been appointed to the new commission created by SB 92, the Prosecuting Attorneys Qualifications Commission. We are seeking a declaration that SB 92 is unconstitutional under the Georgia and federal constitutions, and an injunction barring the commission from investigating complaints or starting disciplinary proceedings. We are bringing 6 claims. First, SB 92 violates separation of powers principles under the Georgia Constitution. The state constitution establishes district attorneys as a locally elected office, which carries with it the responsibility to make discretionary decisions about how best to promote justice and safety in each community. By subjecting prosecutors to discipline for the exercise of their discretionary authority, SB 92 intrudes on their constitutional role. The second and third claims arise under the free speech guarantees of the Georgia and federal constitutions. SB 92 provides for complaints about, quote, stated policies, written or otherwise, end quote, about when not to prosecute certain crimes. This chills prosecutors from articulating their prosecutorial philosophies, but it doesn't only impair the speech rights of those prosecutors, it also interferes with communities' ability to make an informed decision about who they want to elect every 4 years. Finally, the last set of claims, the fourth, fifth, and sixth claims, address the vague grounds for discipline under SB 92. Because the law does not provide meaningful standards for the Commission to apply in evaluating prosecutors' exercise of their discretion, it hands a blank check to the Commission to discipline prosecutors. This is an unlawful delegation of legislative authority under the Georgia Constitution, and it deprives prosecutors of their due process rights of fair notice as to what actions may be subject to discipline, and those rights are guaranteed under the federal and the Georgia Constitutions. Again, we're proud to stand with these district attorneys in pushing back against this abuse of law, and I'm happy to answer any questions later.
At this time, we'll open it up for questions. Yes.
Question for District Attorney Adams. District Attorney Adams, you are a Republican. This legislation was backed by Republicans, passed mainly along party lines. How would you address members of your party about, you did a little bit here, about why you have issues with this legislation?
Yeah, no, absolutely. I think there's a few things that need to be looked at for both parties. You have to be able to see the forest for the trees. Today, we may have conservatives and Republicans in the governor's mansion and in the legislature, but in 5 and 10 years, we may not. And what kinds of laws are going to be passed then that may not best suit small rural communities? Let's talk about Second Amendment infringement that may concern some of those communities versus some of your urban areas. I think there's also been a bigger discussion towards the comparison of the PAQC to the JQC, but I think the difference that we need to look at is you already had a template for the JQC and you didn't use it. In the JQC, 2 of the 3 members of the hearing panel are appointed by the judiciary. You have the Supreme Court appointing 2 of those 3 panel members. And then additionally, under the JQC, you have no provision about discretion of the judges being attacked. And I think those are huge pieces for us all to consider in judicial independence and prosecutorial independence. Thank you.
Yes.
District Attorney Boston, have you changed your behavior since this law took effect on July 1?
I have not.
Have any of the other district attorneys here changed their behavior?
I have a policy that I've had to change. I don't know if it would say behavior. I still think I'm a good person today and was before.
What you're
but
doing as district attorney?
Absolutely. So in September of last year, we had a wife come to our magistrate judge in Monroe County, and she was upset because her husband had been cheating on her. She had text messages to prove it. And in the state of Georgia, a citizen can go to the magistrate court, file an application for a warrant, and have a hearing. And if the law is substantiated with some probable cause, the warrant issues. So we had this individual go into the magistrate judge asking for a warrant against adultery. And so the magistrate judge contacted me and our office and said, "Are y'all prosecuting adultery cases?" And so I was able to send a policy letter to him saying that we don't prosecute adultery cases. Not that I agree with what he was doing, but the fact that that person who should have had his case handled in divorce court, not in criminal court, would have been arrested, would have been booked, would have had to post a bond, and might have even lost his job. I think those are critical things to be looking at. And so, yes, we've had to rescind that policy at this point in time.
And I think what you're seeing are 4 district attorneys who, again, are not operating out of fear, right? But we are standing here in this lawsuit, standing up for not only our colleagues, there are 50 DAs across the state, there are over 100 solicitor generals across the state, and that there are over 2,500 elected prosecutors across the country, for which we are standing to recognize the importance of prosecutorial discretion and prosecutor independence, which we know are being the center of assault today in our criminal legal system. Yes?
DA Boston, yeah, you obviously
prosecutorial discretion is what you're referring to. I mean, we saw a couple years ago in the Ahmaud Arbery case, the DA Jackie Johnson accused of telling police not to arrest the men later convicted of his murder. She was then not elected again.
Correct.
I mean, do you think that that is the oversight that should be, since you guys are elected officials, that it should be the voters deciding 4 years later, a couple years later, that they don't think you're fit to do and not a commission?
Well, first let me just say I'm proud to have, where is DA Brody right here, who stood in the gap and made sure that Ahmaud Arbery's family got justice in that crime when DA Jackie Johnson was not willing to do her job. But to answer your question, not only was she removed by the voters, she was also charged by the Attorney General, and that indictment is still pending for her involvement that amounted to alleged criminal acts in that matter. Additionally, there were other places that could have achieved justice against Jackie Johnson. She could have been impeached by the legislature, and of course, the state bar had jurisdiction to go after her license. And I will tell you, if she's convicted of criminal charges, she will also likely lose her license to practice in the state of Georgia. So there are remedies. Voters are just one remedy. But when prosecutors commit actions or inactions that rise to the level of the severity that we saw in the Ahmaud Arbery case, no one stands by.
So essentially this law isn't necessary, according to you, because there are so many avenues already to get rid of you guys if they want to.
Absolutely.
District Attorney Butler, regarding the timing of this, did it have anything to do with the fact that next door in Fulton County, some charges might be brought against former President Donald Trump?
Absolutely not. And nor did I have any idea that the world would all be watching what's happening in D.C. right now with the special prosecutor, Jack Smith. Absolutely not. This is something that each of these DAs has been incredibly vocal about before, during, and after the legislative session. And since the law was signed by the governor in May, we have been lucky to be working very diligently with our legal counsel to write this legal challenge and to file it in time so that we could be heard before the October 1st date when this legislation would be able to start taking complaints against elected prosecutors in the state. So that was the only deadline that we were considering.
Mr. Rosenthal, how many other states are you taking these recourses? How has the success been?
So we work across the country. In some places, states are recognizing the value of local decision making and are allowing their prosecutors and other government enforcement offices to take steps to meaningfully promote community safety, and we're proud to partner with them in helping move those steps forward. But we've also been fighting back against similar state abuses of power in several states. One recent example is in Tennessee, where we represent the Shelby County District Attorney in Memphis, where the power to address post-conviction proceedings in death penalty cases was taken away from local district attorneys because of how the state didn't like how they were handling them. And we recently were able to secure a victory in that case, ruling that no, this is an authority that's properly granted to the district attorney representing the values of their community. So that's one recent example. And I'll note that we also yesterday, outside of the context of prosecutorial discretion, filed a brief on behalf of several Texas local officials pushing back on that state's so-called Death Star preemption law that takes away the ability of local governments across the state of Texas to regulate in a number of areas. One of the ones that's caught noticeable attention has been the authority to regulate water breaks in extreme heat that was taken away from local governments. And so we were proud to stand on behalf of local officials in Texas to assert their ability to respond to local health, safety, and other needs against this preemption law in Texas, HB 2127.
Mr. Rosenthal, can you walk us through kind of the lawsuit we filed later today in Fulton County Superior Court, your expected time frame, first hearing, and process from there?
Certainly. We're filing the lawsuit today. It'll actually take the form of two separate lawsuits because of certain Georgia procedural requirements. One will be against the state of Georgia, the other is against the members of the commission. In the lawsuit against the members of the commission, we will shortly be filing a motion for an interlocutory injunction to stop the commission from taking complaints or initiating disciplinary proceedings, which we hope to be heard before that October 1st deadline that DA Boston alluded to. And once that is filed, we expect for the court to set a schedule for any further briefing and hearings.
For the district attorneys, did you invite other district attorneys or solicitors general to join you in this lawsuit? And did they decline?
I would say that the DAs that you see up here made the decision that it was important for us to band together and to proceed with this legal action on behalf of a large number of DAs and Solicitor Generals that are very concerned about this SB 92 and this commission. I will say that it's not an easy choice or decision to put your name on a lawsuit and sue the state of Georgia and sue the governor. But what I will say is that the four of us stand very proud that while there are only 4 elected DAs that are on this lawsuit, we are speaking for a large volume of elected prosecutors that are hopeful that we can raise these legal issues, raise these legal challenges, and be victorious in the court legal system. Thank you so much for joining us here today.
Ms. Rhodes, just to be clear, one suit against the governor/state, the other is against the commission members.
The first suit is against the state of Georgia.
Yeah.